the absence of any such agreement, the parties have to bargain in accordance with the provision of the Code. That is to say, comply with the duty to bargain collectively as spelled out in Articles 262 and 264 and observe the procedure outlined in Article 261. The process is initiated by means of a notice served by the party desiring to negotiate an agreement upon the other party, with a statement of the bargaining proposals. The other party has the obligation to make a reply to the notice and the proposals within 10 days from receipt. Should differences arise on the basis of the notice and the reply, either party may request for a conference which shall begin no later than 10 days from the date of request. That signals the start of the actual negotiations where the parties try to overcome the differences and arrive at an agreement. If no agreement is reached on certain issues in spite of good faith bargaining, a state of deadlock occurs with respect to those issues, in which case the parties may exercise their rights under the law. The union may file a notice of strike and the employer a notice of lockout. At this stage, the National Conciliation and Mediation Board, motu proprio, or upon request by either party, whether such notice has been filed, may intervene to help the parties arrive at a settlement. Attendance and full participation by the parties in the conciliation meetings cancelled by the board are mandatory. ULPs in collectives bargaining. There are 3 acts of unfair labor practice that may be committed in connection with collective bargaining, namely, violation of the duty to bargain collectively, payment of negotiation or attorney's fees, and gross violation of a CBA. The first may be committed by refusing to bargain or evading the duty to bargain with respect to wages, hours, or work, and other terms and conditions of employment, bargaining in bad faith, and refusing to execute a contract if requested by any party after agreement is reached. Under the primary definition of the duty to bargain collectively in Article 263, the first duty of the parties is to meet and convene promptly and expeditiously. Meeting and convening are the prerequisites to negotiating an agreement. Therefore, violation of the duty to meet and convene is unfair labor practice, but only if the matters to meet and convene about include wages, hours of work, and other terms and conditions of employment and proposals for adjusting grievances arising under the agreement. These are known as the statutory or mandatory subjects of collective bargaining. A party may, at the risk of an impasse or deadlock, refuse to enter into an agreement unless it includes a desired provision related to a mandatory subject of bargaining. This process is known as bargaining to an impasse. But a refusal to enter into an agreement unless it covers a matter which is not a mandatory subject is to a refusal to bargain about matters which are mandatory subjects of bargaining. The parties, on the other hand, have no obligation to negotiate over non-mandatory subjects or those that fall outside the statutory subjects of collective bargaining. Failure or refusal to meet and convene can be done indirectly, such as where the employer, to evade that duty, indirectly discharge his employees by selling the enterprise to a buyer who was not willing to accept or absorb his employees. The rule here is that if an employer commits unfair labor practice by directly dismissing his employees to forestall a demand to bargain collectively, it is also unfair labor practice to evade that responsibility by indirectly causing the dismissal by selling to a buyer that the employer knows is unwilling to accept his employees. Moreover, if the purchaser was himself in bad faith because during the negotiation for the sale, He was informed of the existence of a bargaining representative and the labor problems in the business being sold. He is in the position of tortfeasor. Having been a party likewise responsible for the damages suffered by the members of the union, cannot justify escape responsibility and is liable along with the seller for the reinstatement with back wages of the former employees. This is an example of the application of the successor employee doctrine, which is to the effect that while an innocent transferee of ongoing concerns lies no liability to the employees of the transferor with respect to either their continuation in employment or the past unfair labor practice of the previous owner, such liability devolves on the successor by virtue of obligations assumed under the contract of sale or because the latter's application in defeating the rights of the employees. The duty to bargain collectively requires bargaining in good faith. A party who bargains in bad faith commits unfair labor practice. Bad faith bargaining, however, has no cut and dry definition. Whether a party is bargaining in good faith or bad faith is a matter that can be determined on the basis of the circumstances attending each case. In Hong Kong and Shanghai Banking Corporation Employees Union versus NLRC, the Supreme Court, citing an American authority, held that there is no per se test of good faith in bargaining. Rather, good faith or bad faith is an inference to be drawn from the facts and is largely a matter for the determination of the NLRC. It has been held, however, that there is bad faith on the part of an employer where his conduct in the course of bargaining, taken as a whole, is incompatible with the expeditious resolution of controversies or disputes pending between the parties.